Okay, everybody, it is noon, and in the interest of everyone's time, we are going to go ahead and get started. I see we've still got some people joining in, but I'd like to say hello and welcome. Thank you for joining us today as we learn more about the basics of estate planning. What do we need to know beyond a will? I'm Ellen Richardson, Senior Director of Alumni Engagement at the NC State Alumni Association and a member of the class of 2001 and 2010. It's a pleasure to be involved with the founding of Wolfpack Women in Philanthropy, a group of diverse, multi-generational, multidisciplinary professional women dedicated to growing, recognizing, and celebrating women's philanthropy, leadership, and engagement to NC State. For the past 3 years, this group of inspiring women has come together to develop this program. And while we're still evolving, it's a great way for women and really everyone to learn more about NC State, about philanthropy, and about ways to get engaged as volunteers, as mentors, and as leaders. I do have one housekeeping item for our session today. If you'd like to submit a question for Katherine, you may do so in the Q&A box that's located below your webinar screen. We'll answer as many questions as possible in the time that we have today, and we will provide follow-up on anything that we aren't able to get to. This brown bag lunch is the first in a series that will continue this fall that will cover topics like tax-advantaged giving and planned giving vehicles. The next session is slated for November, so to be sure to be on the lookout for more information about that. We are recording today's session, so we will be providing that for everyone who is registered. It will also be located on the Alumni Association's YouTube channel if you'd like to check it out or share it with friends later. And now I am pleased to introduce Katherine Miller, Director of Planned Giving here at NC State. Katherine's an expert in all things planned giving, including the topic we're learning more about today, estate planning. Katherine has been at NC State for 4.5 years. Prior to NC State, she was a tax manager at Deloitte Tax LLP and brought with her a wealth of experience and knowledge that has helped many of our alumni and friends with their philanthropic planning. So I will turn it over to you, Katherine. Take it away.
Wonderful. Thank you so much, Ellen. I appreciate that. And I really appreciate the Alumni Association and Wolfpack Women Philanthropy for hosting this session today and allowing me to spend this time with you all. It's a very exciting opportunity to talk about a really important but often pushed to the side topic because now the first moment it's probably not the most fun for folks. So I appreciate you setting aside your lunch hour to join us, and we'll keep it as fun and interesting as possible. Before I share my screen and get my slides up, I want to introduce my co-host here, Devan Colbreth, who is a wonderful colleague of mine in our Office of Gift Planning. Devan is our Associate Director of Gift Planning here at NC State, and we've been lucky to have her for about 3 years. Prior to coming to NC State, Devan specialized in estate planning in local practice in the area with a focus on special needs trust and elder care law, so very knowledgeable. And she has kindly agreed to help me manage the Q&A during this session. We are expecting some robust questions. So as you all submit questions through that Q&A feature, Devan will be answering as many as possible throughout the session while I'm presenting. Also received some pre-submitted questions that were done with registration, and I've incorporated some of those into the presentation itself. I'll be addressing others at the end of the presentation, and as Ellen mentioned, anything that we are unable to get to, whether it was pre-submitted or submitted today and just can't get to due to volume, we will absolutely be providing some form of follow-up on that. So please ask away and we will answer them just as quickly as we can. So with that, I'm going to share my screen so you all can see the slides, and we'll get started here. Okay, all right, so give a shout out if anybody can't see that, but hopefully you're seeing what I'm seeing, and we'll get rolling. So today's topic is estate planning beyond the will. Obviously, wills are a hugely important part of estate planning, but there is so much more to that comprehensive and holistic process than just wills. And so we'd like to kind of cover all facets of that. My objective here today is to introduce you all to the various concepts and tools that will enable you to assess your current estate plan, or what I like to refer to as the state of your estate, to consider any potential pitfalls that your current plan may have, and to identify any unaddressed concerns that may not, have been properly considered or addressed as part of those written plans, and to leave here today a little more prepared to discuss some options for either putting an initial plan in place or updating your plans with your family and trusted advisors. So, with that, I'll give my official disclaimer that although my office has a wonderful professional background, we draw upon, I myself, as Ellen mentioned, have a accounting background. I'm a CPA and worked in public practice, working with high net worth individuals on their estate planning, estate compliance, and individual tax planning and compliance. And Devan and another one of my colleagues have a wonderful legal background we draw upon. Any advice we give is obviously general to what we see in gift planning, particularly as it relates to philanthropic moves folks are making here at the university. We have a wealth of knowledge to draw upon, but we always encourage you to speak with your own advisors about your specific situation, because of course there's always something special that makes every situation different. So hopefully this will just give you a general sense of what things are looking like in the world of estate planning and leave you a little more prepared to discuss that with your own advisors. So we often hear that an estate plan is only for the wealthy, but is it? Then that's a trick question, because it's not. If you didn't know, I'm here to inform you all today that everyone on this call already has an estate, whether you're aware of it or think of it in those terms or not. Your personal effects, your bank accounts, the cars you're driving, the home you may live in, any investments that you have, perhaps a retirement plan through your employer, those all comprise your personal estate. And in addition to that, when thinking about estate plans, it really goes well beyond simple asset distribution. So although you do have an estate of assets, there are many considerations folks think about in making those plans. Guardianship is always an important question and component. Do you have minor children? Do you have special needs children? Do you have elderly parents that you may be charged with caring for? Perhaps you have guardianship over them, or you're helping to support them. Estate plans often also include medical decisions, both related to end of life care, but also for periods of incapacity that you may experience during your lifetime, a significant illness that you may be able to recover from, but during which you are unable to manage your own affairs. That is often considered part of an estate planning process. In a similar manner, financial control during your lifetime, again, if you were to experience a period of incapacity, much in the same way that you would want to provide for medical decisions to be made on your behalf during that illness, have you made provisions for financial decisions to be made on your behalf? So those medical bills can get paid, the lights in your house can stay on, utilities get paid, someone is managing your investments if it's perhaps a prolonged illness. We also, obviously, in what we do here at the university with our Office of Gift Planning, we see a lot of folks that are interested in making charitable gifts as part of their estate plans to all sorts of organizations that are near and dear to their hearts. So there's so much more to a holistic estate plan than a simple distribution of assets. But it's extremely common for folks to avoid making estate plans and put it off. Very understandable and very common. Some of the most common reasons are people being uncomfortable thinking or talking about their passing. Oftentimes we hear that they just don't want to have to go to a lawyer. Either they feel pressed for time, it's not a good time to undertake what they feel will be kind of a long process, they're too busy, perhaps they just don't want to pay right now for will and trust preparation. Oftentimes that blends into the third reasoning here, which is that they may not want to pay for that attorney's time until they feel fully prepared to walk in and say exactly what they want their plans to be. But many folks have a hard time coming to decisions on key issues that will be part of those plans. Guardianship for those children or elderly parents that need care. Is there a clear a clear person to step in and provide that. Who you will name as the executor of your estate. You know, for some folks, it's a really obvious choice, and for others, it's not at all. It is a very difficult decision to come to, and one that they wrestle with, and really takes them a long time to make that determination. Also, deciding about the distribution of assets and who will inherit is also not a simple decision for many people. There can be concern over family discord. So although the fact that you've even made estate plans at all, or what the specific nature and content of those plans is, never needs to be disclosed to anyone other than, you know, your attorney who may be drafting those plans and yourself. Many folks feel compelled to share that information with their loved ones when they're going through that process. Although again, that's certainly their decision and their right to share or not share, but many folks feel the need to share that, and they may feel uncomfortable sharing that information, what that reaction might be from family members about their decisions. So all of these reasons work together to prevent folks from, you know, moving forward with getting their estate plans in place. But as you all know, obviously, because you've chosen to make the time to log on here today, it is such an important thing to do to make sure that your plans are documented and laid out in a manner that really fulfills, you know, your vision for your legacy and how you want to provide for those that you're leaving behind. The last thing I'll mention is that we often hear folks say that they're too young for estate plans. So, you know, maybe when they're retired, they'll get to that, but they're too young for that. And as I mentioned earlier, each and every one of you already has an estate. So, you know, I don't believe anyone is too young for estate planning. If you don't have a plan for your estate, the state that you live in or country that you may be in has a plan for you. And as we'll get into in a few more slides, I think you'll see that oftentimes those plans really aren't a great fit for most folks. So it's important for you to kind of take that power and seize the control and make sure that your plan fits your life and your vision. So you can't really be too young for that. One of the pre-submitted questions I mentioned that we'd received was about what age or life stage folks should start thinking about estate planning. As I said, I don't think anyone is too young for that. Once you're out of school and working and have some assets to your name, you know, even if that's just your employer retirement plan or some life insurance policies through your employer, you know, you should really be thinking about that. But then certainly as layers of life progress and as you get married, particularly thinking about providing for your spouse, particularly with respect to any joint debt that you may assume together, cars or houses, to make sure that that debt burden doesn't fall too heavily on them if something were to happen to you. And then of course, you know, children, guardianship is always a major concern to think about early on, as well as providing for their financial care. So certainly many reasons to start your estate planning at a young age, and, you know, continue to keep an eye on it and revise it as your life evolves. So I want to talk briefly about what happens if you don't plan. You think, I'm too young for that, or I'm too busy for that, or I'll get around to it later, and later doesn't come. What, as far as getting around to making those plans, what happens? So some of the assets that you own will pass via asset ownership. So the legal way in which they are owned or titled will determine how they are passed on to your heirs. Some assets will pass via beneficiary designation, and everything else that does not specifically fall into those categories as being predetermined to pass via titling or beneficiary designation, everything else that would typically pass under a will had you made one, then falls subject to the laws of the state that you live in, called the intestate succession laws. As I mentioned, your state has a plan for you if you don't have a plan for yourself. So I know that some of you signed on here today may not live in North Carolina, but I think that this provides a good example of just how, you know, relying on state laws, varied as though they may be, is probably not a great answer for most folks. Many folks are surprised to learn what state laws actually provide for, as it's often not what they might have expected and certainly what they may not have desired. So in North Carolina specifically, should you fail to make a will, anything that would have passed under that will, the spouse, a surviving spouse, will always inherit something, but usually not everything. Children will always inherit something, but again, usually not everything. And that is regardless of their age. Minor children legally are not able to own property in their own name, but they still take under intestate succession, which can create some complications. So that's certainly something to keep in mind and consider. And in North Carolina, your parents will inherit something if there are no children. So if you have a spouse but no children, then your parents will receive part of that estate. So I'm not going to go through this slide in exhaustive detail, but I wanted to give you all an opportunity to kind of see with a little bit more specificity what your situation might look like, for example, in North Carolina. So hopefully you can kind of narrow in on which category may apply to you as far as if something were to happen to you, who would be surviving you at this point and what that would look like. I'd like to point out a great example of why this may not be a good fit for many folks. If you look at the fourth, fifth, and sixth bullets here, where you are married and your spouse survives you, and you either have parents that also survive you or children that also survive you along with your spouse, what you'll find is that your spouse inherits something, but not everything. And so a great example of why this can be very problematic for folks is, let's say you had purchased real estate prior to your marriage in your name only. And when you married, your spouse moved into that home, and that became your joint primary residence for many years. But you never took the formal step of going and having your spouse's name added to the deed so that that real estate remained titled in your name only. And you also had not prepared a will that left that real estate to your spouse. Then if something happened to you, your spouse would inherit either 1/2 of that real estate in shared inheritance with either your parents or one surviving child, or if you have multiple children, they would actually only inherit 1/3 of that property. So the home we're talking about that may be their primary residence, they are suddenly a 1/2 or 1/3 owner of, with your children who may be minors, or perhaps your parents. For some folks, that may be an acceptable outcome, but for many folks, that is probably not what they would have anticipated or desired with respect to a primary residence. So I think that's a great example of why it's so important to take steps during your lifetime to understand what the rules are, and assuming that those may not be a good fit for your situation, to provide for an alternative plan. Okay, so today we are going to go through several different types of estate planning tools. The first significant category I wanted to mention is the transfer of assets. So there are a variety of ways that, as I mentioned, that assets can be transferred. It can be done via asset ownership, the legal way in which it's owned and titled, beneficiary designation, through the will, or through a revocable living trust, which is something I'll get into a little bit more detail shortly. Another important category of estate planning tools is care during your lifetime. Many folks handle that through creating powers of attorney. Those can be, financial or healthcare related. Typically, those provide power to the named individuals to make decisions on your behalf in either a financial capacity or a healthcare capacity. And it can be the same individual, but typically they're separate powers of attorney that are created. And I think it's really important to note when thinking about a healthcare power of attorney that is quite different from what many folks know as a living will or an advanced healthcare directive. A living will is what you want to happen. So it kind of states the decisions that you would like to have happen, but the healthcare power of attorney is what actually grants the agent the ability to make those decisions on your behalf. Additionally, the living will typically does not cover many medical decisions that may be unrelated to specific end of life decisions. So again, if you were to experience some sort of long-term prolonged illness, needed someone to make decisions on your behalf, but you were expected to recover from it, the decisions that they'd be making, may not be laid out in a living will. These powers of attorney, many folks will go ahead and set up now and create during their lifetime and set those up because of course they're for use should something happen during your lifetime. Those are durable powers of attorney many times, which are created now and exist. They're in effect immediately. If you have loved ones, a spouse or children or other loved ones that you're very close with and you feel very comfortable with them kind of having that on file, you're not concerned that they're going to run out and start making decisions on your behalf while you're capable. Many folks just choose to go ahead and get that set up and get that paperwork squared away. Other folks are very uncomfortable with the idea that someone may have immediate power to make financial or healthcare decisions on their behalf when they themselves are perfectly capable at this moment in time, and they may be reluctant to create that existing power, in which case they may look into what's called a springing power of attorney. And that is something that they can create now. They can go ahead and have the document prepared. They can name who the agent would be in the event that they were unable to make decisions themselves. And that power of attorney is not effective immediately. It would not be effective until such time as it may spring into effect, hence the name of it. And typically that is, there's very prescribed circumstances upon which it would be considered to spring into effect. So a very common scenario would require your personal physician to determine that you were unable to make decisions on your own behalf, and at that point it would spring into effect. I just want to quickly note a different type of power of attorney that you all may be familiar with. Some of you may have created specific powers of attorney in the past. Those are typically good for, just very limited situations and often very short in duration. A very common example is if you're purchasing a home and you are unable to be at the closing to actually sign the documents and the deeds yourself, you may have signed a specific power of attorney over to a spouse or to your own attorney to allow them to sign, for example, those home closing documents on your behalf, and that power of attorney was only good for those specific actions. So typically something like that would not necessarily be part of your estate planning process, but it's a type of power of attorney that many folks are familiar with. The last major bucket I want to mention here as far as tools utilized in the planning process is thinking about guardianship or ongoing control over assets. So situations where a simple distribution of assets after your death may not be the ideal answer. There may be myriad reasons why putting some kind of parameters and ongoing oversight on how those assets are being utilized may be desired. And so certainly those issues can start to be addressed through a will, and also very commonly for the control perspective through a revocable living trust. Right. So as you approach your estate planning, I would encourage you to take time to sit down and think about what your own goals are for the process, what your goal is for how things will end up after your plans are followed, and any unique concerns that you may have about your specific situation. So do you have minor children that you need to think about guardianship and providing for their financial care? Do you have adult children with special needs where, again, guardianship and ongoing financial care may be something you need to make provisions for? Do you have elderly parents that you are either a guardian for or that you are providing financial support to, that you would want to ensure that that continued should you pass before your parents? Blended families, many times that adds significant complexity to the estate planning process. So that's always something to consider. Do you have a family business? And if so, do you have plans for that to be unwound when you pass, or do you have a plan in place for it to continue? Do you have family members or loved ones or close employees that plan to take over that business, at some point in the future? And do you need to put plans in place to make sure that they are able to do so should something happen to you, before you would have handed over control during your lifetime? So if you're still, kind of the full owner of that business and you haven't started transferring ownership as part of a retirement plan, that you're exiting and you're ready to head to the beach and enjoy the golden years, if something were to happen before that while you're still the majority owner, how would that ownership be transferred, and are those plans in place? Do you own real property in another state? That's always very important to consider, that you may be looking at not one set of state laws, but perhaps two or even more, depending where you own real estate. Real property owned in another state would, of course, be subject to those state laws as to how it may be lawfully passed. And what other unique family considerations you might have with your own circumstances. And also, do you have any charitable wishes, organizations that you care deeply about and you would like to leave a legacy at? And if so, is that something that is in your current plans, or does that remain to be addressed? So we're going to start to get into some of the meat of the matter here, now that we've kind of teed up all the areas to be thinking about and why they're important. The first category I'd like to talk about is assets that transfer outside of a will. So I mentioned that there are certain assets that will transfer upon your death, regardless of a will, via operation of law or by contract, simply based on how those assets are owned or titled. So many folks, have experience with owning assets jointly. Great example, of course, is married couples, but certainly can be other cases of joint ownership as well. That may be real estate, cars, joint bank accounts, and things like that, where multiple names appear on the title to the asset itself. So the deed of the home, the registration of the vehicle, the bank statements have multiple names listed. And if those are owned, you'll see the notation here, JTWROS. That stands for joint tenants with right of survivorship. That is a very common mechanism for owning things jointly, particularly for spouses. And in that case, the way that is titled, where it specifically, you'll see that lettering, the JTWROS, is part of the titling on many of those things, like the bank accounts and such. That means that whoever survives the other owner automatically, by operation of law, has a right of survivorship to ownership of that asset. So if you owned, of course, a house with your spouse, or a car, or a joint bank account, let's say, when you pass, if that is owned under that JTWROS structure, immediately, kind of no action needed, other than kind of notifying, of course, places, but your spouse has assumed full control and ownership of that asset simply by operation of law. Anything you write in a will with respect to those assets does not make a difference, because they have already transferred as a matter of law. Of course, if you own real estate, cars, bank accounts, investment accounts in your name only, and no other name appears on that title, then it is not going to transfer by operation of law, because it's owned to someone else, because it's owned in your name only, and those would be assets that would fall under the will. So you would transfer real estate or vehicles or bank or investment accounts owned outright in your name only through a will. Other folks, you may see some of these assets owned jointly without a right of survivorship. that through the tenants in common ownership mechanism, that would be very common, for example, to own property with a sibling, perhaps a vacation home that you've purchased with a sibling or a friend. And you own it as tenants in common. And again, that would, although it is a shared ownership, you don't own 100% of the entire asset. Your interest is severable and transferable. And so your interest in that would pass under your will, or, as determined by state law in the event that you don't have a will. So if you owned, let's say, a beach house with your brother as tenants in common, and you left it in your will to your children, then when you pass, your children would own a 50% share of the beach house, and your brother would continue to own a 50% share of that house. So they would share that together. Another category of assets that transfer outside of the will is assets that transfer by contract. And typically that would be like a beneficiary designation situation. Many of you are probably familiar with this through having set up either retirement plans or life insurance. Oftentimes when you initiate those plans or policies, you are prompted to complete a beneficiary designation form. And the individuals or charitable organizations that you list on those plans or policies take ownership of those assets upon your death, irregardless of whether there is a will or what may be in that will. So the only way to change the beneficiary on these type of assets is to actually update your beneficiary designation form with the specific account custodian or policy issuer. So that is something that even if you've updated your will, let's say there was a significant life event and you married or divorced or had children or whatever it is, and you want to change your estate planning structure, you need to be sure, in addition to updating your will, to contact these different retirement custodians or life insurance issuers and update your beneficiary designation forms for your individual accounts and policies, because whatever you may have updated in your will does not cover these assets. We are also seeing more and more these days, certain banks and brokerage houses offer the ability to put in place what is called a pay on death, a POD form, or a transfer on death, TOD. It just depends on which asset you're talking about. But what that does is essentially converts an asset. So for example, a bank or a savings account or an investment account that may be owned in your name only. And traditionally that would pass under your will, assuming it remains titled in your name only. And they're instead offering the option to complete what is effectively a beneficiary designation form for that account. And it basically moves that asset outside of the probate process, and it converts it into an asset that then transfers by contract as part of that beneficiary designation form, rather than falling under the will itself. So that's a really interesting opportunity that has come up and is now available to folks. It offers a way to, again, move these assets outside of the probate process, oftentimes, that enables the named individuals that will inherit the account to receive the funds more quickly, because they're not waiting for the probate process to be completed before they can access those funds. So that can be a very effective planning tool. And of course, just like with traditional beneficiary designation forms, you can change those at any time. It's a beneficiary designation. You're not providing any sort of current, ownership. So you always can revoke that or change that at will. To make a few notes here, you'll see on the bottom side of the screen to think about when you're looking at these type of assets. With respect to bank accounts, I mentioned at the very top, and asset ownership. It's extremely common, as folks get older, if they have children nearby, we see this a lot, that their children may start helping them with managing their affairs, particularly if they're experiencing illness, and a child that lives nearby is helping out with getting bills paid, getting things managed while you're focusing on your health. And oftentimes it seems very simple to just go down to the bank and add that child to the account so that they can have access and do what they need to do because they're helping you take care of things. And I would encourage you in that situation to consider the impact of what you're doing from an asset ownership perspective. It may very well be what you intend and desire, which is great, but we often see that folks don't understand the implications of adding a child to an account for that purpose, that what they are doing is currently granting that child and equal ownership in that existing asset, and also creating a right of survivorship oftentimes in that asset, particularly if there's other children that weren't added to the account because they're not nearby and they're not the ones managing the affairs. That's vested a right of survivorship in that asset to just one of perhaps several children, and may have some unintended consequences. It may be preferable to speak with your bank about the option to add someone with signature authority rather than granting them actual ownership of the account itself. Additionally, when thinking about beneficiary designation, specifically retirement plans and workplace retirement plans, to consider if you are naming a non-spouse beneficiary, whether that be your child, grandchild, or a charitable organization, or just a friend. Many workplace, I would say most workplace retirement accounts fall under federal ERISA protections that actually require spousal consent for a non-spouse to be a beneficiary on that account. So it is absolutely something that can be done. You can name the child or the friend or the charity, but oftentimes your spouse has to agree in writing to that and have that agreement from your spouse be on file with that custodian in order for that designation to be honored because of those federal ERISA protections that are in place. And lastly, I wanted to mention, particularly, we see this a lot with the beneficiary designations. It used to be very popular, particularly with retirement plans or life insurance policies, to simply name your estate as the beneficiary. So you would write in as your beneficiary on the form, the estate of Katherine Miller or the estate of whatever your name might be. And then that asset would transfer legally to your estate upon your passing and follow the prescribed distribution for your estate, what may be laid out in a will or trust or the general estate probate process. However, that can create some significant complexities and definitely some unintended tax consequences to name an estate. Typically when an estate is named as the beneficiary, ultimately it is still going to be distributed in some manner to either outright to an individual or a charitable organization, or perhaps put into a trust for the benefit of some individuals. And so I would encourage you to simply bypass the estate step, which can create some unintended consequences, and just name outright the beneficiary that it would go to once the estate filters the assets out. So whether that be the individual or the charity or the trust, you can name a trust as the beneficiary of many assets. You can simply just go ahead and note that instead of filtering it through your estate. Oh, and a revocable living trust, I wanted to mention that we're going to get to that in a little bit more detail in the next slide or two, but that is another way to transfer assets outside of a will, and we'll dig into that, like I said. All right. So as you are considering will preparation, some things that you'll want to keep in mind. First of all, keep in mind that probate is a public process. One of the most common reasons for setting up a revocable living trust is to protect privacy. Trusts protect privacy as far as who is receiving assets, financial details of those assets and things like that in a way that the probate process does not, particularly with folks who have, perhaps some family businesses or, other concerns that they may not want, like the financial details related to some of those affairs, being available in the public sphere. Using a trust to protect the privacy of those can be a great option. A revocable living trust is something that is established during your lifetime. So you would go ahead and set that up with an attorney, and as a legal entity, it exists today. Or, when you sign that trust document, it is created as its own legal entity. However, in many ways, you and the trust are one and the same, although legally it's technically a different entity. You, as the grantor of that trust, you can put things in, you can take them back out. And for tax purposes, you are considered one and the same. So if you were to put an asset into the trust that has income related to that, that would simply be reported through your own tax return filing. It doesn't require, separate tax returns, during your lifetime. So that can be a great way to go ahead and get something set up and in place, give you the opportunity to retitle assets, to move them into the trust. As I mentioned, you can certainly take them back out at a later date if you decide that that's no longer ideal, but to go ahead and move them in there. And then, immediately upon your passing, what happens is, the trust then becomes a separate taxpayer. They get its own tax ID. The trust is kind of sheltered in place. It kind of locks in, and it already has, of course, you've already set it up. The paperwork's there to prescribe what happens as far as the assets that you had been utilizing and enjoying during your lifetime, how those are then going to be distributed. But the details of that are not subject to public information. So many times folks will go ahead and set up a trust like this. They'll move perhaps a number of their assets into it, but oftentimes it's not everything, right? There's always things that are left out. And so what they'll do is they'll say, and their will be very simple. Like I've seen some incredibly short wills. You'd be shocked by how short they are, because it just says, I leave everything to my revocable living trust, and have, of course, the trust name there. And that's all it says. And everything goes to the trust. And so the only thing that is being publicly disclosed is that you had a trust and that you've left everything to it, and no details on what is being left, or who, or how those distributions are being made. Additionally, as you think about considering, preparation of your will, we mentioned wanting to consider guardianship issues. Also, that's when you would consider if you have any specific bequests that you would like to be made to loved ones or charities. Specific bequests can be made either as a set dollar value or a percentage of your estate. So you could say, I want to leave, $10,000 to this friend, or, to each of my grandchildren. Or you can say, I want to leave, 10% of my estate to my favorite charity. You can also have specific bequests to cover those family heirlooms and prized possessions, make sure that your grandmother's china gets to the right place, and so on and such forth. Oftentimes you will outline your wishes regarding, burial and funeral arrangements that may be written into that will. And wills allow, for a lot of complex planning. So whereas some of the things we mentioned that transfer via contract or operation of law and titling, that just is what it is, and the contract is what it is, and the beneficiary is who they are, and it's very simple. Wills, you can start to have a lot more layering there. You can create trusts. So if you don't set up a revocable living trust during a lifetime, you can set up a testamentary trust. A testamentary trust is something that is created under your will. So it outlines the terms of the trust, and it essentially springs up into existence upon your passing. That may be used, for example, some people create, trusts for their pets, under their will, or of course, children, perhaps, especially if it's minor children and it's a trust that you may not ever need to come to existence, but you'd want assets held in trust if something should happen to you when they were minors. And then of course, it may not come to fruition if the terms of what's laid out isn't there. Trusts also allow for a lot of complex planning. So whether that be the testamentary trust created under your will, or that be the revocable living trust that we just talked about, where you create it today, really allows for that ongoing control that we mentioned, that some folks may feel the need to have a little bit more control over an extended period over the distribution of assets. You could decide, for example, that you want to preserve some wealth, and that you want assets to be held in trust, and you only want the beneficiaries to receive income and not have access to the underlying principal value of the assets. Or you may decide, it's very common, particularly with kids, whether or not you have concerns about their ability to handle money. Some folks just do it regardless. Some folks have kind of kids they consider spendthrifts and are very concerned that the assets may not last into their older age. And so they will decide to set terms of a trust. Again, this could be a revocable living trust. You could build it into that where, when that trust is fully distributing to others after your passing, you can set terms such as, I want it distributed, a third when they're 30, a third when they're 40, and a third when they're 50. Or perhaps it's tied to life events. Perhaps there's some amount upon, college graduation or marriage or birth or various, birth of children and various things that you would allow distributions for to kind of help them with certain expenses or life events. But they can't get their hands on everything all at once. It kind of preserves it and protects them to make sure there's something there later on. So there's very, very complex planning that can be achieved with that. Some common pitfalls I'd urge you to consider would be using an attorney that you know instead of one who specifically specializes in estate planning. Estate planning is very complex and very nuanced. State laws vary greatly, and there can be a lot of unintended consequences. What you think may be a simple will, if it's not properly drafted because someone isn't aware of certain requirements of a state law, may not be able to be followed and upheld. Also, I think I mentioned, not updating your estate documents or your beneficiary designations upon significant life events. So to make sure that you're holistically considering all the pieces that would need to be updated as part of your plan. Of course, leaving assets to minor children without planning. So oftentimes, if you anticipate that assets may need to go to minor children to set up some form of trust, whether that's existing today or something outlined in your will, since they can't legally own that property outright, to provide for someone to help manage that property on their behalf until they come of age. One I always like to highlight is having estate documents that are not easily located or accessed. So you can have the best plans in the entire world. You can have spent tens of hours and thousands of dollars creating these plans, and you're just so thrilled you've thought of every last detail. And if nobody can find them or knows that you've made them, then your estate very well may go through the probate process. So while of course the contents of your plans are very personal and you may not wish to share those, I would always encourage you to share, whether it's a loved one or a friend or just a neighbor, hey, I have plans and, I have stored those in my safety deposit box or the safe in my house, or, they're under my mattress. Give them a heads up so that if it's the family, they themselves know where to look, or perhaps a friend that can alert the family to where your special hiding place may be so that they can find those and follow all of your wishes. And another pitfall, of course, is not understanding how an asset passes. So someone may think that they are able to designate under their will, for example, how a retirement account should be distributed, or how a jointly owned asset should pass, a jointly owned asset that had a right of survivorship. And of course, that will provision would be invalid because that is not how that asset passes in a legal sense. I did want to address quickly a pre-submitted question we received about whether online wills work just as well as ones drawn up by your local attorney. So online, I know those become increasingly popular. There's a lot of resources out there. I will just say that, online companies' documents certainly may be honored as long as they conform to state law. So making sure that you're working with a site that you feel comfortable with, that is specific to following the laws of your state. In addition, oftentimes those programs will end with telling you to print and sign it. So of course you would need to do that. And because it would need to conform to state law, you would need to understand whether that needs to be, witnessed or perhaps, often notarized in just like a will that your local attorney would prepare in order for that to be valid. Okay. I know we're running short on time, so I'm gonna get through a couple more slides as quick as I can, and then we'll jump into a few questions. So a word on trusts. So some of the benefits I've mentioned there. Trust can be significant in terms of providing privacy. They can be significant in terms of providing ongoing control. I mentioned, being able to lay out terms of distribution, whether that's ages or life events, various things like that. Additionally, the terms of distribution, for blended families, trust can be a very powerful way to make sure that your spouse is provided for after you pass, but also ensure that your assets after taking care of your spouse for the remainder of their lifetime will revert back to your own children. Very, very common use of trusts in blended families. And as I mentioned, they allow for very complex planning. I think some of this we've covered, the trust set up during your lifetime, if it's a revocable living trust, which is a very, very common structure, no returns will be needed during your lifetime. You and the trust are one and the same. That being said, upon your passing, the trust would become a separate taxpayer that would need to file annual income tax returns. Accountings would have to be done. So that's something to consider, the need for that when deciding whether or not to set up a trust like that. I'd also encourage you to think about whether the terms of your trust allow enough flexibility to account for unforeseen circumstances. Does the trustee have any discretion? So in the example I described, perhaps you wanted your children to get their distributions, maybe it's age 40, 50, and 60, and they get a third of the trust upon reaching those ages. Does your trust have provision to allow the trustee flexibility? For example, if one of your children encountered significant medical issues, perhaps they experience a disability or significant illness and they're struggling financially because of that, it may be that, of course, you would have wanted for them to have access to funds to cover those medical expenses, to pay for medical care, or to keep them at a certain standard of living if perhaps they're having trouble maintaining that because of a disability. So is there flexibility then to allow the trustee to use some discretion and advance some assets beyond those simple, age distributions? And lastly, particularly if you're setting up a very specialized trust, such as a special needs trust or a pet trust, really to ensure that the attorney that you're working with is very experienced in that particular area. So these are very nuanced trust structures, a lot less common, so they're not seen by as many attorneys. So I would make sure that the person you're working with is extremely familiar with that. I'll just briefly mention that many donors we work with here at NC State choose, of course, to create a lasting legacy here at NC State or other organizations they care about by leaving a bequest. That can be done as a gift in their will, either via a set dollar value or percentage of the estate, a beneficiary designation on a retirement account or life insurance, or those POD, TOD forms I mentioned that turn the bank or investment account into a beneficiary designation as well. Something we hear a lot is that folks want their estate plan to reflect their values and priorities, and they want to leave a legacy behind. So I think with that, I think we've just got about 5 minutes left, so we'll jump to some questions. I just wanted to address quickly a couple pre-submitted questions we received, and I know Devan has been tracking questions here as well. Devan, I'll jump to you. Do you have any pressing questions, and then I can come back to my list?
Well, I actually have a few that we should probably answer live, but it just depends which ones you'd rather do first.
Yeah, no, hit me with your best ones.
Okay. Well, one of the pre-submitted questions was actually, how would we suggest going about finding a qualified attorney?
Mhm.
And I was going to that is one of the questions that has been submitted, but the best way is that the North Carolina State Bar actually has a website and an email address that you can use, and they will help you find someone. The other thing is, if you are in the Raleigh-Durham, Chapel Hill area, we have a list of folks that has multiple attorneys on it that we will send you if you request it from us. But the other questions involved whether or not powers of attorney, wills, and similar documents drafted in another state are still accepted in North Carolina. And what are your thoughts on an attorney serving as the executor of an estate? And I answered them privately, but you are more than welcome to answer them publicly, or I will.
I'll defer to the answers that you've provided there in the Q&A. I think everybody should be able to see those. Like I said, I know there were a lot of pre-submitted questions, wonderful questions. Unfortunately, have not been able to touch on all of those today in the time that we have, but please know that if you did submit questions either ahead of time or during this session, and that was not answered, we will be getting information out to you. So appreciate your patience with that, and appreciate the questions and just such a wonderful volume of them. It's a wonderful problem to have. I'll get through a couple in the few minutes I have here. Someone asked, the best estate planning tips when you have no children or direct line for generational wealth. So some thoughts on that are that common plans in that situation might include charitable gifts, and also assets left to other loved ones, whether that be extended family or close friends. Oftentimes in that situation, a common question is who to have serve as executor. So perhaps is there a sibling or niece or nephew or a close friend that could be entrusted with that? Depending on the nature of the relationship, it's not uncommon to potentially include a small gift for that executor in the estate for kind of agreeing to take on the burden of handling all of those affairs. I would also urge you in those situations, if you're naming, a sibling, a niece or nephew, a friend, what knowledge of and ease of access do they have to your estate planning documents, right? So you kind of let them know where things are, that they can kind of find those easily if they're perhaps not as familiar with your hiding holes as, children maybe. Someone asked about ways to avoid probate outside of using a living trust. So of course, as we mentioned, asset ownership titling and beneficiary designation are outside of probate. I wanted to mention that, in some states, you can additionally use a transfer on death or power of transfer on death or pay on death, like deed, for real estate or vehicle registration, although that is not permitted in North Carolina. There are some states that will allow you to put like a transfer on death designation for real estate. So that's certainly something to look into should you live in a different state. As far as avoiding probate for the other assets that naturally fall into the probate category, some states allow expedited or simplified probate procedures for small estates, what they consider to be a small estate. In North Carolina, typically that relates only to personal property and has a pretty low threshold, perhaps about $20,000. Also, some states do allow for simplified expedited processes where the surviving spouse inherits everything, but it's often difficult to avoid probate entirely. There's just some things that may just fall in that bucket. So the best you can do is have it in a will and have it move through quickly and simply. I'll touch briefly on, someone asked about the pros and cons of transferring parents' assets into your name before their death. What would the pros and cons of that be? I think the biggest pro obviously would be avoiding probate because those assets are transferred already. But there are a lot of considerations for something like that. I would strongly urge you to research and to speak with an attorney before making any significant transfers of that nature. Transfers of parents' assets into a child's name, before death could trigger gift tax reporting with the IRS upon that transfer. The parents may end up needing those assets during their lifetime, and a transfer back could again trigger reporting to the IRS. Additionally, assets that are transferred to a child during the parent's lifetime typically transfer if they're appreciated assets. So some real estate or investments that have appreciated greatly would transfer at the parent's carryover basis, and the child would then owe gains on all of that appreciation at such time as they sell that asset. Whereas if the asset transferred upon death, typically there's a step up in basis, and if it were to be sold immediately, there wouldn't be any capital gains tax owed. So that can be a significant consideration. There can also be impacts to Medicaid eligibility. If parents run into a situation where they have a significant medical costs, long-term care, there's Medicaid look-back periods of about 5 years to uncover any significant transfers during that period, and those folks may then be penalized through either delay or denial of those benefits. So certainly a lot to consider in that scenario. I know we are running right up on time here, and I want to respect everyone's time. Thank you so much for joining us here today. I've included here on this last slide the website for Wolfpack Women in Philanthropy. I hope you might consider taking a few minutes to look at what this wonderful group is doing. Again, I'm so appreciative of them hosting this session today in collaboration with the Alumni Association. I'm grateful for the opportunity to be here speaking with you all. The contact information for my office is listed below. If you care to reach out, would love to hear from any and all of you. And again, I just wish we could have gotten to more questions, but I want to respect everyone's time. We will get those answered for those that were submitted. So please don't fret. You will get your answer, I promise. And again, thank you so much.
Yes, thank you, Catherine. Thank you, Devan, for your time today and for sharing your knowledge with us on this. And we will be emailing out the recording of today's session and the slides and following up on questions. So I hope you all have a great day. Thanks so much for your time.